Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about Gladue. Cases that should have gone to the Supreme Court of Canada, but didn't. Jussie Alululuk was a person who is Indigenous, who was charged with a criminal offense, and at his sentencing hearing, he did not present any Gladue factors. Neither the Crown nor the defense requested a Gladue report be prepared, and no Gladue factors were led at the sentencing hearing. When a sentence was ultimately imposed in his case, Mr. Alululuk appealed his sentence, arguing that it was unreasonable not to consider his Indigenous heritage as a factor in determining what a fit sentence was. On appeal, he applied to and successfully was able to admit fresh evidence by way of a Gladue report that was not prepared at the time, but the Court of Appeal did not alter or change the sentence that was given to him in the end, upholding the same sentence that the sentencing judge had originally imposed. He sought leave to the Supreme Court of Canada, and they denied the appeal. And this case raises very important questions about what role really do Gladue reports play. If the Gladue report was erroneously not included in the original sentencing position and original sentencing submissions, and ostensibly contained information that provided more insight into the circumstances that led the accused in this case to be in the position that they were in, how could it be that the sentence didn't change even a little bit as a result of the introduction of the Gladue factors? If courts are supposed to take into consideration the effects of colonialism on an individual and how that led to them coming before the court as an offender, does that not have any weight when those factors are actually added in? And how can that not have an impact, even if it's only in a minor way, on the imposition of the sentence? Also, when a sentencing judge is crafting an appropriate sentence, they're supposed to look at the circumstances of the individual offender, looking for things like their level of moral blameworthiness, their culpability, and those factors couldn't properly be taken into consideration by the sentencing judge without the Gladue material that was ultimately deemed to be relevant. So how could the absence of that Gladue material lead to the same sentence for the same reasons that was imposed? The Supreme Court of Canada should have taken this opportunity to explain and better outline how Gladue factors should be considered when they're introduced as fresh evidence in appellate level courts on sentence appeals. And unfortunately, the Supreme Court of Canada didn't provide that guidelines, and it leaves us with all sorts of questions about really what is the role of Gladue if it's not going to alter the outcome or alter the analysis that led to the outcome. Unfortunately, the Supreme Court of Canada, I think, missed the opportunity to really correct a confusing outcome in this case that asks more questions than it really answers. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.